Yesterday we had covered our syllabus relating to the interpretation of statutes till the golden rule of interpretation. When we talk about the golden rule of interpretation, it is, we will say that the wider explanation of the literal rule of interpretation. As we had already discussed, when we talk about the literal rule of interpretation, it goes with the exact meaning or the original or the natural meaning of the language that has been mentioned in the legal text of any statutes. In the golden rule, basically the judges can deviate from the natural meaning of the legal text that has been mentioned or we derive from any legal statutes. But it has clearly been laid down while applying the golden rule that first step that we have to follow is to go with the literal meaning or the grammatical language of the legal text only. It means whenever we are going through any of our barrates of any statutes, or we are going through any legal text, first thing is go with the dictionary meanings of those words or the natural meaning of the words. If that natural meaning creates any ambiguity, injustice, iniquity, hardship, or it is against the justice delivery system, only then the our judicial system or our judges can deviate from the natural meaning and try to find out or look into the purpose behind the statute. Now, when we are talking about the purpose behind the statute, we have to keep in mind golden rule clearly lays down that when we are talking about the purpose, we don't have to look into the purpose of the particular provision of any barrate. Say, for example, if you are dealing with section 498A of the IPC, and while going through the provisions of this section, if the judges think that the language of the section is creating any injustice, or it's ambiguous in its meaning, or it's vague in its meaning, then they have to find the purpose behind the statute. Now they have to go through the statute. What is the purpose behind the Indian Penal Code, not the purpose behind the that particular provision. That is the second step that has to be followed while we are interpreting the golden rule of interpretation. And after that, we have to go through the intention of our legislators while this act has been interpreted, or act has been enacted, or this act came into force. Because after that, why we say that golden rule is very, very important, because after this we discuss internal aids and external aids. Now here you should keep this thing in mind. I'm saying again and again that our judges or our judiciary has to keep in mind while interpreting the golden rule that what is the purpose and intention when this act was passed, when this act was enacted, or when this act came into force. Okay. So while talking about the golden rule, we can analyze this rule into 5 parts. First of all, because now it's clear that we will apply the golden rule of interpretation, where we deviate from the literal meaning of the words, and judges try to interpret the provisions or the legal text of any statutes as per the situation or circumstances of the court. Whenever there is any doubt in the legal text, and that doubt creates injustice to the parties. When we analyze this rule of golden interpretation of statutes, it came into existence first of all in Warburton's versus Loveland case, where the Justin Burton observed that whenever we are interpreting the statutes, the first step that we have to follow is to go to the literal meaning of the words that has been laid down in the legal text of any statutes. If those literal meaning of the statutes create any kind of absurdity, or they are ambiguous in their meaning, then we should find out what is the purpose or intention of the legislative assembly while passing this act, and then the judges may interpret this rule in their wider concept. Because we had discussed what is the difference between interpretation and construction. So here, while interpreting that particular provision, they can construe the new sentence. The judiciary judiciary may come with the provisions that under those provisions only, under that verdict only, which are helpful in delivering the justice in those particular circumstances or in that particular case law. Again, in Gray versus Pearson's case, which is a case of 1957, for the first time, Lord Wensleydale coined this term golden rule of interpretation. And after that, this wider interpretation of the literal rule of interpretation of statutes came to be known as the golden rule of interpretation. Again, Lord Wensleydale clearly laid down that when we are interpreting the statute, we have to go through the literal meaning of the interpretation. If literal meaning is not able to deliver the justice, then the judges can go to the wider interpretation of those particular legal text of the statutes. Now, another point is Hayden's rule of mischief. Again, when we have discussed the mischief rule of interpretation of statutes, we have clearly discussed whenever there is any mischief in any statute, then to provide remedy for that mischief, the judges can introduce the new language. They can add on the words that will clarify the meaning of that particular legal text in a statute. So while applying the golden rule of interpretation, we have to keep this thing in mind while deviating from the original meaning of the interpretation or of the legal statutes. Are we able to provide the remedy to that particular mischief? Because that is the basic purpose of interpretation of the statutes. Now, if the original meaning is not providing remedy, if the original meaning of the legal text is not able to deliver the justice, then we have to substitute the words. We have to construe the new sentences. Then those new sentences shall be able to provide the remedy and remove the mischief in that particular legal text. So whenever we are interpreting the golden rule of interpretation, it has been laid down by Lord Greenworth that there are certain basic principles that the judges should keep in mind. And these are the, first of all, whatever may be the result, if the meaning of the wordings of law is plain, then they should be applied as per the literal rule. Means if they are simple in their meaning and we don't find any ambiguity or vagueness in those words, however, they may not be able to deliver the justice, then the judges should try to apply those legal text only. And if it's not able to deliver the justice, then they can give suggestions to the legislative assembly to brought about the amendments in those particular statutes. For example, I had discussed it yesterday also, when in the Nirbhaya's case, judiciary find out that in the juveniles cases, the age may be lowered, keeping in mind the circumstances of the society in the present scenario, because all of us are having overexposure, especially our teenagers, with the advent of internet, with the advancement of technology. They are having all the information before the coming of the age. Then the Supreme Court has clearly laid down that it is the right time to reduce the age of majority from 18 to 16 years. That is the case where, of course, the simple meaning of the legal text wasn't clear, creating any ambiguity. The courts has applied that, but the courts find out that with the advancement in the society, with the introduction of new forms of internet or the technology, there is time to bring about the changes in that particular statute itself. For example, in the same way, under Article 21 of the Constitution, right to education has been introduced as Article 21A of the Constitution, where the education for the children between the age of 16 years to 14 years has been made as a fundamental right, because that was the need of the hour. So the first rule that we have to keep in mind, or the judiciary has to keep in mind while they are interpreting the legal text of any statutes, that first of all, if the meaning is quite plain and it's not able to deliver the justice also, then they have to apply the plain meaning only. And if they find out that even after applying the plain meaning or the original meaning or the natural meaning of the words, it's not able to deliver the justice, then they can take the further step. The second point that judges have to keep in mind while applying the golden rule of interpretation is, unless there is any ambiguity or absurdity in the wordings of the law, the ordinary sense of the law should be restored to as per the golden rule. The second principle that has been applied by the golden rule, that without any reason the judges should not go to the wider interpretation of the statutes. If there is no ambiguity, if the meanings are clear, there is no vagueness in the words, then they shouldn't unnecessarily try to give or try to construe the sentences or the new sentences which may deviate from the original meaning of the particular legal text of the statutes. Another principle that has to be kept in mind by the judges while applying the golden rule of interpretation is, the general policy or intention of the statute must be considered and eliminate the evil which was directed as per the mischief rule. While applying the golden rule of interpretation, if the judges find that the original meaning of the text is not able to deliver the justice for the intention for which that act has been laid down or framed or came into force, then they should try to find out, or they should construe the sentences as per the intention of that particular statute only. For example, when we talk about the preamble to the Constitution, as we know that word sovereignty was added by the 42nd Amendment only in the preamble itself. Only when our judges find, or the Legislative Assembly find out that that word goes with the provisions of the wordings or the legal text of the preamble, and it may widen the scope of the justice or the intention that our Constitution wants to convey to the citizens of India. After that, when we talk about the applicability and usage of the golden rule of interpretation, we had already discussed it in detail, that we have to keep in following principle in mind while we are applying the golden rule of principle. First of all, we have to go to the literal meaning or the natural meaning of the legal text, and even if that natural meaning is plain or clear or very simple in meaning and is not able to deliver the justice, then the judges should go with that plain meaning only and should take next step after that. Secondly, whenever they are interpreting the golden rule of interpretation of the statutes, if the simple meaning or the natural meaning is not able to meet the requirements of that particular statute, then the judges should go with the intention of the statutes. And the third principle that we have to keep in mind while applying the golden rule of interpretation is that whenever we are applying the golden rule of interpretation, we should keep in mind the journal policies. Means we had already discussed that there is law, then there is statute, there is act. Law means in the journal sense, the legal system in the territory of a particular country. Statute means bunch of laws. Act means a particular law. So whenever we are applying the provision or giving a golden interpretation, or we are going with the liberal interpretation of the statutes, we have to keep in mind journal policies also, so that it shouldn't go against those journal policies also. So however, sometimes this golden rule of interpretation has faced the criticism also, that judges may deviate from the original intention or the purpose of the act. They may be partial in the cases or in the circumstances. But if we go with the history of our justice delivery system, it has rarely happened that our judiciary has been partial in the justice delivery system. So we can say that golden rule has been applied successfully by our judiciary till this date. So next is the rule of harmonious construction. So as per this rule, whenever there is conflict between two or more statutes or two or more parts of a particular statute, then the rule of harmonious construction needs to be adopted. This rule follows a very simple rule that every statute has a purpose and intent as per the law and should be read as a whole. But if there are two provisions in the statutes which are apparently in conflict with each other, then they should be interpreted such that they should not be in conflict with each other, and one statute should not go with against the other statute, or the one statute should not override the other statute or renders the other statute inoperative. So the approach should be such that a harmonious relationship, a friendly relationship can be adopted between both these statutes. For example, if we say that the age of voting is 18 years, so we are considering that as soon as any person, whether it's a male or female, it turns out to be the age of 18 years, they are having the fundamental right to vote. But when we come to the marriage purposes, we say that age of marriage for a male should be 21 years and for a female should be 18 years of age. And sometimes, of course, in some of the states, the age to consume alcohol has been raised to 25 years only. So we cannot say that why there are conflicting provisions relating to the age. So there are reasons for that, and if the need arises, then we should go with the interpretation which may not create conflict between these provisions. We can say, of course, whenever a person, because right now we had discussed Nirvya's case also, where the Supreme Court is saying that the age of majority in some cases can be reduced to 16 years also. So these are the conflicting decisions relating to the age only. But here we are having valid reasons for that also. As in Nirbhaya's case, the person who was of the age of 16 years has committed the crime in the most heinous way. And when we are talking about the voting rights, we are saying that yes, whenever a person turns out to be the age of 18 years, he is the person or the mature person who is able to understand the things in a better way. And when we are talking about the marriageable age, so we had kept it 18 for female and 21 for males, keeping in mind the development of the bodily structure, so that they should be able to lead a healthy life. And when we are talking about the age of consumption of alcohol, again, keeping in mind the circumstances of a particular area or a particular state, the government may make rules so that there should be peace, brotherhood, and the youth could be saved from all these alcoholic or drug addiction activities. So in the same, because I had given very simple example so that we should be able to understand what we meant by rule of harmonious construction. So it says whenever any two statutes are in conflict with each other, we can say now that constitution is to saying the age of majority is 18 years, then why is the age of marriage is we have kept it at 21 years of age? We are having valid reasons for that. Or maybe in the same statutes we may have conflicting provisions or the legal text, as in the for the marriage only we are saying for at one side under the article 14 of the constitution we are talking about the right to equality, and in the Hindu marriage act we are saying that it should be 18 for female or if 21 for male. We are having valid reasons for that, because due to the bodily development, so that they should be able to lead healthy life, we have kept the age criteria. So this is the rule of harmonious construction. So case on the point is, first of all, Ishwari Khitan versus Sugar Mills. What happened versus state of UP? What happened in this case? The state government proposed to acquire sugar industries under the UP Sugar Undertakings Acquisition Act of 1971. This was challenged on the ground that these sugar industries were declared to be controlled, one by the union under Maharashtra's Development and Regulation Act of 1951, and accordingly, the state didn't have the power of acquisition of requisition of property, which was under the control of the union. But the Supreme Court held that the power of acquisition was not occupied by the central government under the Act of 1951. The state had a separate power under the entry 42 of list 3 of the constitution. Another case on the I will not be discussing the other case because it goes on the same lines, and we are having a little bit of time constraint also here. Okay, so after this rule of harmonious construction, we come to the rule of adjustum generis. So adjustum generis is a Latin term which means of the same kind, or we can say of the similar class also. It is generally presumed that a statute will be interpreted so as to be internally consistent. Internally consistent means it shouldn't go with the justice delivery system, or we can say that when we are talking about Indian legal system right now, we know that the constitution is the sovereign law or the supreme law of the land, and the any other laws that were in force before the coming of the constitution, or we are making after the coming of the constitution, should not go against the provisions of the constitution. If they go, they will be considered as null and void. So a rule of adjustum generis is based on that. It says that whenever a particular section of the statute shall not be divorced from the rest of it, then the because I think under the constitution we discuss these doctrine also, that when this rule of adjustum generis is applied to resolve the problem of giving meaning to groups of words where one of the words is ambiguous or inherently clear. For example, if we are using any sentence and we are not able to clearly understand why this particular word has been used in that particular sentence, and even after finding out the dictionary meaning, we are not clearly able to understand how we are going to interpret this word with the rest of the sentence. Then in that case we should try to find out the meaning for that particular word, or the substitution for that particular word, which will go with the rest of the sentence, so that the sentence which is creating a meaning should be inconsistent with the rest of the statute. The case law on the point is of Maharashtra University of Health and others versus Sachit Kitprasarak Mandal and others. In this case, Supreme Court examined and in the meaning of adjustum generis as a rule of interpretation. While examining this doctrine, the Supreme Court laid down that, of course, it means of the same kind or nature, and it is a principle of construction, which is when general words in a statutory text are flanked by restricted words, the meaning of the general words are taken to be restricted by implication with the meaning of the restricted words. Because already we had discussed that we are having we should go with the strict interpretation of the statutes, means we should go with the literal meaning or of the words that is being used in any legal text of the statute. Only when those restricted or the literal meaning creates any ambiguity, absurdity, or vagueness, then we can go for the construction of the sentences, but keeping in mind the intention and purpose of that particular statute in mind. And whenever we are applying the rule of adjustum generis, we should go with the meaning of the sentence, and if any particular word is restricting the meaning of that particular sentence, then we have to keep in mind while applying this rule, in what way will serve the purpose of the statutes or will serve the intention of the statute. So another rule is the expressio unitis est exclusio alteris. Again, this maxim is given to find out the intention of the legislature, which says that if the words used in any legal text of the statutes are plain and its meaning is clear, then of course there is no scope for the application of the rule. But this rule means that express mention of one thing implies the exclusion of another, because exact meaning of the term expresso units est exclusio altres means when one thing is expressly mentioned, it means or implies that exclusion of another thing. When we are talking about the exclusion, it often results in the inadvertence or accident, because it never strikes the draftsman that the thing supposed to be excluded requires specific mention. This maxim generally is considered not to be in application when it leads to inconsistency or injustice. Means sometimes, even when we go through our bare acts, we find out that sometimes the words has been used in such a way which may not have clear meaning, or the application of those words in that particular sentence doesn't suit us. But when we find out, or when we go to our reference books or textbooks and we go with the case laws, then we get a better understanding how those words has been excluded by the judiciary, because they were not properly applied, or their application was not proper, or doesn't go with the intent, purpose, or the true meaning of that particular sentence. Then another maxim is the contemporaneous expositio est optima et fortissima in lege. Again, this maxim means that contemporaneous exposition is the best and strongest in law. It means where the words used in a statute have undergone alteration in meaning in course of the words will be construed to bear the same meaning as they had when the statute was passed in the principle expressed in the maximum. Or we can say that old statutes should be interpreted as they would have been at the date when they were passed, and prior usage and interpretation by those who have an interest or duty in enforcing those particular acts. And if the statute appears to be capable of only interpretation, the fact that a wrong meaning had been attached to it for many years will be immaterial, and the correct meaning should be given by the courts. Sometimes it's also happened because when we are talking about the our statutes or our acts or laws, of course they are being drafted by our legislative assemblies, and in our legislative assemblies there are human beings only. They may have interpreted any legal text of any statute at a particular time as per the words that were prevalent at that time, or they had interpreted those legal text of the statutes as per the circumstances that were prevalent at that particular time. For example, when we read our IPC, sometimes we find that the fine has been kept at 500 rupees, 50 rupees, 100 rupees. So sometimes we think that what is the value of 50, 500 or 100 for such criminal activities at present time. But with the advent of time, or with the justice delivery system, our judges has raised the amount of those fines also. So whenever we are going through these Indian Penal Code or the provisions of the Indian Penal Code, as per this maxim, first of all, we should go through the original text of that particular statutes. Then we should try to interpret the present punishment system or the fine system that has been laid down. Then we will be able to compare it in a better way, and to will be able to understand it in a better way, why the originally the fine was kept at 50, 20 or 100 rupees, and now in the present situation why it has been raised exemplary. So another maxim on the point is the nocitur eoesis. It means it is known by its associates. Or we can say sometimes when a particular word is being used in a particular sentence, and when we look at the meaning of a particular word, then it doesn't give any truthful sense in that particular sentence. But when it is being read with the full sentence or other words, then it gives a meaning to that particular sentence or word. So whenever such situation arises, that's why we say now, whenever we have to go through any statutes, we should read the bare language. And whenever we are reading the bare language, we should try to understand the true meaning. Maybe sometimes the individual word is not giving any truthful meaning or genuine meaning, or meaning that may be helpful to that statute. But if it is being read with other words or with the complete sentence, it may come out with the genuine meaning that is applicable or that is fruitful, that particular provision of the statute. So next is the strict and the liberal construction of the interpretation of statutes. So as we had already discussed, when we are talking about the interpretation of the statutes, we first of all we are saying that we should go with the literal interpretation, or we can say that is the strict interpretation of the constitution. And another thing we are saying that because we had discussed mischief rule or the golden rule of interpretation, that keeping in mind certain circumstances and conditions and following certain principles and rules that has been laid down by our judiciary from time to time in a number of cases, we can go with the liberal interpretation of the constitution also. Same goes with the construction of the statutes while interpreting the statutes. We had discussed now what is the difference between interpretation and construction. Interpretation means to derive the meaning of the legal text that has been used in the statutes as it is. Construction means when the true meaning or the natural meaning of the legal text is not able to serve the purpose of justice, then while substituting or adding new words, we can construe the sentence keeping in mind the purpose and intention of the statute in mind, so that it can serve the purpose of justice for a particular statute. So when we are talking about the strict construction means that we should go with the letter to letter interpretation. Whatever sentence we are construing, it should not go even for a tiny step against the purpose and intention of that particular statutes. But in the liberal construction, sometimes maybe we may construe or construct the sentences in such a way which are not going exactly with the meaning of the original text, but it is going with the intention and purpose of that particular statutes or law. Generally, courts favor strict interpretation or the construction of the statutes, because then the label or the burden is not on the judges, but on the statutes that has been laid down by our legislatures. However, if the true meaning or the original text is not clear or ambiguous in its meaning, then the court generally favors the golden rule or the mischief rule of interpretation. When we talk about the taxing and the criminal laws, they are being constructed very strictly. So that's why generally when we talk about the taxing or the criminal laws, we don't find any errors and we go with the strict interpretation only, because in our taxing provisions and in our criminal provisions, very strict data or the original data is being used. And if the judges go with the liberal or the interpretation or the construction of these statutes, then it may create confusion and it may differ from case to case, and then the true purpose or intention of the statutes may not be met. So this is about the interpretation, strict interpretation and liberal interpretation of our statutes. Next, we come to our internal aids and external aids of construction. Now, first of all, it's very, very important to understand what are these aids or these helps, why we had labeled them as internal and external. So we had already discussed again and again that whenever we are talking about the interpretation of the statutes, it means we are trying to understand the meaning of our legal text that is being used in the statutes or in the acts or in the laws. So whenever this legal language is being used, we use grammar in a proper way, or we can and when we grammatically we are applying the rules, and this is known as the internal aids, where we come to know, for example, if we go with the punctuation marks, if the comma has been used, we know that now we are breaking the sentences. If hyphen has been used, we know now we have to take a break and think how these two sentences are connected. If the question mark is used, then we know that now this statute itself is raising the question whether these laws should be applied or not. These are the internal aids that I will discuss in detail also, what kind of internal aids we are using in our interpretation of statutes. Then another is the external aids. Now, what we understand by the external aids, for example, when we use dictionaries, when we aren't able to understand the meaning or intention behind a particular statute, then we go through the legislative history. Now, what we meant, when I had been discussing the golden rule of interpretation, I had said it again and again that we should go to the history or the legislative intent. What were the reasons for the passing of this particular act? For example, if we are talking about the Dowry Prohibition Act, so when we are talking about the Dowry Prohibition Act, we will go through the different provisions. Now the question arises, sometimes the question may arise that why we are discussing about the Dowry Prohibition Act, why there was need for the dowry prohibition. So first of all, we have to go through the legislative history. If we are not able to, because we will be able to interpret that law properly if we know why this act was passed, what was the need at that time for the passing of this act. Or from Dowry Prohibition Act, we can go to the Sati Abolition Act also. The question may arise because nowadays I think rarely any woman is getting sati. Now the question arises, why there was need for the Sati Abolition Act. So we can understand only if we will go through the legislative history, then we will know why there was need for the passing of the Sati Abolition Act. That all those are the external aids. When sometimes we are not able to find out the true interpretation of the statutes, or sometimes the hindrance is to find out the true meaning of the words that has been used in the legal text, then we take the help of our internal aids and the external aids. So when we are talking about the internal aids, first of all is the short title. Short title means, for example, the title that has been given to your acts, for example, Hindu Marriage Act. So we know Hindu Marriage Act means it is dealing with all the rules, ceremonies, conditions relating to the marriages of the Hindus. Indian Evidence Act, that is the short title. Na? So we know that it is talking about the evidences that can be used in the trials. Indian Penal Code, so we know we are talking about the Indian Penal Code, means it is talking about the punishment provisions. So these are the short title. Short title is being given to every act so that we should be able to understand for which subject matter that particular act is dealing with. Then we come to the long title. Long title is a kind of objective which is being used in the statutes, and which let us know the basic purpose or the basic intention for which this act was being passed. For example, a long title of our CRPC or the Code of Criminal Procedures says, an act to consolidate and amend the law relating to criminal procedure and that of the Prevention of Corruption Act relating to criminal procedure, right? So it means ki whenever we are talking about the CRPC, it is talking about all the procedure which is being followed in the courts relating to any criminal offenses or anything which is being done against the law in a criminal way will be dealt under the criminal procedure code, right? For example, next is our we are talking about the Prevention of Corruption Act of 1988, and its long title says an act to consolidate and amend the law relating to prevention of corruption and matters connected within. Okay, so next is the preamble. So preamble generally tells us about the objective, intention, purpose behind the statute for which it has been passed. For example, we are having preamble to our constitution, which clearly tells us what our constitution wants to give to the citizens of India, or we can say preamble is the key to open the minds of the makers of that particular statute. Our next internal aid is the marginal. So marginal notes are notes that are inserted in the side section of the act to express the effect of the section. Sometimes they are also known as the side notes. However, nowadays we are not using side notes because sometimes the provisions of a particular section are quite long, because we will be having a clause and sub clause in a particular section. So rather than to go through the whole provision or the whole section, we use side notes or marginal notes, which clearly tells us what we will find out in that particular section. But nowadays we are not using these marginal notes, or they have. So other internal is the headings. Generally headings are attached to almost each section, just preceding the provisions. For example, when we talk about our CRPC only, you take any section, say we take section 437. So the heading will be when bail may be taken in case of non-bailable offences. For example, we are talking about the Article 21 of the Constitution. Heading will be the right to life. So we will come to know that the basic thing or the basic talk that that particular provision is going to talking about is that particular subject matter. If we are talking about Article 21, it will be talking about the provisions relating to life. If we are talking about the Article 14, it will be talking about the right to equality and gender justice only, right? And then another internal aid is the definition or the interpretation clause. So generally, when we go through our any bare act, we found the provisions. It's generally section 2 or section 3 in most of the cases in our most of the acts, where certain words has been defined, or which is known as the definition portion, where the definition of different words has been given, which are being used importantly, or which are the or those words which are the basis of that particular statutes. The definition of those words are being given in section 2 or section 3, or sometimes in some of the acts it's section 4 also, in the starting of the statutes itself. Next we come to the another our internal aid, that is the punctuation marks. Of course, we know the different punctuation marks are being used in our Beric language also, which tells us where we have to take the break, where we can break the meaning, where the question is being asked, where the issue is being raised. Another is the illustration. So of course, we know in many of our provisions or the sections or the articles, when we are going through them, illustrations are being given with those provisions, so that we should be able to understand that particular section in a better way. Exceptions is the another internal aid. Exceptions and saving clauses are being used in our provisions or in our sections and articles also. So exceptions means we come to know that if we are applying that particular provision, then it is not applicable in certain circumstances. And in the exceptions or the saving clauses, those circumstances are mentioned where that provisions may not be applicable. Explanation, sometimes there is need to explain the provisions also, and in the bare act language only those provisions are being explained in detail, so that we should be able to understand how and where we are going to apply those provisions. Then schedules. Schedules are generally attached to any act which deals with how to claim particular rights under that particular act. For example, we know that we are having 12 schedules in our constitution, in which the important aspects of our nation has been discussed, so that we don't have to go through the different articles of the constitution. We know this thing has been mentioned under this schedule, this thing has been mentioned under this schedule. That is to tell that these are very important aspects of the nation, and they should be dealt differently or importantly, so that the basic purpose, that is justice, justice, and it could be delivered in a better way. So this is about the internal aids, and next is the external aids. Next PPT, please. Of course, I had already discussed that internal aids means to understand our statutes in a better way, and sometimes internal aids are not enough to understand the statutes or the legal text of the statutes in a better way, so we need external aids also. So external aids is sometimes it's statement of objects and reasons, means it's to understand what are the basic object for which that particular act has been passed, or what are the reasons for which this act has been passed. For example, I had already discussed about the Sati Abolition Act. So the reason to prevent the woman from getting a sati, and object is to have a better society, to have a better life for our women counterparts. And another external aids are the commentaries on the laws, which is being given by various authors. Of course, we read many books on a same subject. Different authors have interpreted the same provisions differently with the help of case laws. Then dictionaries, which tell us the meaning of the words, and we are able to understand the legal text in a better way. And when we are talking about the dictionaries, we are having two kinds of dictionary. First is the English dictionaries, or where we are using a meaning English to English or English to any other local language. Then we are having legal dictionaries also, where the legal words which are being used in the statutes are being defined, what are their exact meanings. We are having references to reports of committees. Then we use historical background. For example, if the Constitution of India was passed, then it is very, very important to go through the circumstances of 1947, means to go through the history, why these fundamental rights were introduced, why the policies of reservation was laid down in our constitution. That we can understand only with the help of the legislative history. Then administrative conveyancing also, how the different reports, rules, acts, statutes has been administratively administered, implemented, and how the policies has been made. That is very, very important external aid to have a better understanding of our statutes. Then the commercial practices is another external aid. Sometimes we go for the, we say now we are going for the field study, or we are going for the doctrinal work, or we are going for the survey work to find out how a particular act is being applicable or understood in the society. Now, those are the practices being followed, and this is the another external aid. Or foreign decisions are also used to understand, as we say, because we had adopted our legal system from the British. So in many of our statutes statutes while interpreting them. We go through the British case laws also, then political, social, and economic development, because it also shape any nation, circumstances of the nation, and of course then its legal system. So after that we come to the remedial and penal statutes. So the interpretation, first of all we come to the interpretation of taxing statutes. So I had already discussed while giving the example that whenever we are talking about the taxing statutes or the criminal statutes, we generally go with the strict or the literal interpretation, because when we are talking about the taxing statutes or the criminal statutes, we are using facts and figures. We are introducing the data after a very deep study, and if we go with the liberal interpretation of these statutes, it may create confusion in the society itself. Then is the principles of constitutional interpretation. Again, when we interpret the constitution, generally we adopt the principle of strict interpretation. And whether it's A.K. Gopalan's case or the cases basically before the Keshwan and Bharti's case, we have gone or we have adopted the principle of strict interpretation only. Even in the Keshwan and Bharti's case, there was a bench of 13 judges in which the 11 judges gave different opinions. It was only after the Maneka Gandhi's case that we adopted the approach of liberal interpretation in our constitution itself. We have seen that in our Article 21 itself, we have give rise to a number of laws, while the judiciary has laid down different decisions or different aspects of our life has been given to us as a fundamental right. Because in right to life itself, starting from right to have a free and pollution free water, we have come where even the right to sleep has been guaranteed as fundamental rights. Right to have medical debt has been guaranteed as a fundamental right. After 1978 or after the Maneka Gandhi's case, in the field of constitution also we have interpreted it in a very liberal manner, but keep following the true intent and purpose of the constitution, keeping in mind what our preamble is laying down, but also inconsistent with the changing scenario of our society. From social engineering theory, we have come to the stages where we had adopted the principles of welfare democracy these days. So when we are going for the interpretation of the constitution, we follow certain theories also, or there are certain rules. First is the rules of harmonious construction. Of course, for that constitution itself has laid down the provisions that whenever there is any conflict in any parts of the statutes or between the two statutes, then the principle of harmonious construction will be applied. But generally, when we are talking about the constitution, we say that provisions of the constitution prevail. But as we had differentiated the different subject matters under the three lists of the constitution: union list, state list, and concurrent list. And if there is a conflict, generally the union laws prevail. But we had already discussed a case of overcoming of or overtaking of the sugar mill industries in the state of UP, where Supreme Court has clearly laid down that keeping in mind the circumstances, because all those sugar mills were working in the state of UP. State of UP was generating revenue from those mills. The farmers were getting benefited. Then only the state government has a right to overtake those sugar mills. Then another doctrine of pith and substance that is being followed in the constitution. It this doctrine basically says that, first of all, if there is any confusion, we should try to find out whether it's possible to differentiate those subjects, or to put those particular subject where any conflict is arising into different categories. And if it's possible, then it should be categorized differently. And if it's not, then we should try to find out the true meaning, what it wants to say. And then by interpreting it properly, we should try to find out the solution where there shouldn't be any conflict relating to the laws or the interpretation of the constitution. And is the doctrine of colorable legislation, which says anything which we cannot do directly, that work we cannot do indirectly also. For example, if sometimes our legislators lay down certain laws, then they cannot interpret those laws in a way which goes beyond the purpose and intent of that particular legal text of the statutes. And to have a check on that, we are having judiciary. In many of the cases, judiciary has given direction to our legislatures or the parliament to look after or to go through the provisions which are not basically statute is saying something and government is doing something else. In those cases, our courts has given directions and has strictly reprimanded our governments also to take proper actions. And because when we are talking about the principles of legislations or the methods, we had again discussed is, first of all, we should go through the text or the legal text of any statute. If that's not or by going through the text we are not able to understand the meaning clearly, then we should go behind the intention. And if even after going through the intention it's creating confusion, then we should try to find out the purpose. So intentionally textualism, intentionalism and purposism are the three methods which we generally follow while interpreting the legislative legal text. So I think this is all about the interpretation of the statutes. To have a discussion on this very important subject of law, that is the interpretation of statutes. So I'm really very thankful to Team PLEA.
Thank you, ma'am.